Okay, so good morning, everybody. It looks as though we've got some people joining our seminar presentation this morning. I'm just waiting for the participants to file into the system. So if you could just bear with us for a moment, that would be good. Hopefully you are seeing what is on the screen. Yes, we've got people rolling into the seminar presentation, so that's fantastic. So good morning, everybody. My name is Tony Linane. I'm the Director Regulatory Programs with the New South Wales Resources Regulator, and I'd like to welcome you this morning to our online video conferencing public consultation session for the statutory review of the Work Health and Safety Mines and Petroleum Sites laws. We'll be joined today by the independent reviewer, Kim Bills, who I'll introduce to you shortly. But first of all, we'd just like to go through some housekeeping issues in relation to today's session. We're doing an online session, as you're aware, so just a few protocols for people to be mindful of. During the presentations today, all participants, apart from Kim and myself, will be on mute. However, there will be an opportunity during the course of the session this morning for you to be able to come off mute and ask questions. Obviously, we'd just like to remind you that this is an open forum, so we just ask that you be respectful and use appropriate language, which I'm sure nobody has any problem with. And just a note too also that we are recording the session today and we'll be making this available on our website for people who have been unable to attend any of the face-to-face sessions or the online sessions today. They'll have the benefit of being able to dial in and have a look at the presentation which goes through the review. You'll notice on the screen that there's a little Q&A button that's been highlighted. That's to enable you to type in questions as we go through the session this morning. Plus there's also an opportunity to raise your hand in a virtual sense. And that will allow us to unmute you and have you ask a question. So you should see those at the bottom of your screen. Could I just ask if you would mind just clicking on the raise hand button, just so I can check that you're actually hearing the audio. And yeah, great, Jeff Hender and Dave Bolton, fantastic. Everyone looks to be able to put up their hands, so that's brilliant. So thank you, everybody. You can now or lower your hand. You'll see the little button there to be able to do that. So that's great. So as I said, just during the course of the session, if you wanted to ask a question, all you need to do is to raise that and we can monitor that. And I guess the key point is to allow us to have a coordinated and orderly discussion. Obviously, it's a bit challenging if we have 10 or 20 people all speaking at the one time. So that's pretty much how it works. If you are dialing in on your phone, and I know we've got at least one attendee today who has done that, and you'd like to raise your hand, you can do that by pressing *9 on your keypad. So that will allow you to do that. So that's what you need to do to ask a question if you're on phone. So first of all, we'd just like to acknowledge the traditional custodians on the lands on which we are gathered today, and we are gathered right across the state, and we pay respect to elders past, present and emerging today. So the outline of the session today is that we'll be looking at the key issues of the review and the discussion paper. We'll be having an open discussion of sorts. Obviously not as we would do in a face-to-face session, but we'll be doing it virtually. But there's certainly an opportunity for you to either pose a question in the Q&A section, which you can type, or raise your hand when we open up for discussion to make a comment or ask a question. And then looking at why we're here today, well, this is really about giving you an opportunity to understand from Kim's perspective, what are the key aspects of the review, but importantly, to enable Kim to get a good understanding of the key issues from your perspective. And we're doing that to help guide you in terms of making submissions and encouraging formal submissions. And it's important for Kim's perspective to be able to have a good appreciation of what are the major themes that have been raised by industry stakeholders and industry participants insofar as the legislative framework is concerned, and will help him in developing the report for the Deputy Premier. We're doing the statutory review because, as the name implies, it's required by law. So the Work Health and Safety Mines and Petroleum Sites Act has a section that says that 5 years after its introduction and then ongoing, that the government has to do a review of the Act to determine whether or not it's meeting its objectives. And it's been 5 years since the Work Health and Safety Mines and Petroleum Sites Act and regulation commenced. And in effect, it's been 5 years since we've put into place the outcomes of the National Mine Safety Framework. So it didn't make sense to look only at the Act as part of the review. It was important to consider the regulation as well, because they both commenced on the same date, 1 February 2015. And as most of the detail in the regulation of work health and safety in mines is contained in the regulation, it seemed a little bit unusual to only look at the Act and not consider the regulation together. So that's what we're doing as part of the review. And it's important too, because it's the first time that the regulation of work health and safety in mining in New South Wales was brought together in one legislative framework for all mining sectors. And the other thing we'd just like you to be mindful of too is that the Work Health and Safety Mines and Petroleum Sites laws, which apply to mines and petroleum sites, are also part of the Work Health and Safety Act. So the Mine and Petroleum Safety Act and regulation are to be read and construed as if it's part of the Work Health and Safety Act, which many of you would be familiar with already. However, just to note, we are not doing a review of the Work Health and Safety Act and the Work Health and Safety Regulation. So they're a separate piece of statute that are looked after by Safe Work New South Wales, and they're not being reviewed at this time. So the focus is only on the mines and petroleum sites legislation. So the process kicked off on the 1st of March with the release of the discussion paper, which I'm sure many of you have had an opportunity to have a brief glance at thus far, but Kim will be going through that in more detail today. What we are doing is that we're encouraging formal submissions on the discussion paper, and clearly that will be a focus for many large stakeholder organisations and companies. However, if you're an individual, you're a participant in the industry, or you have an interest in the industry, there's also an opportunity to participate in an online survey as a way of you providing your feedback on the review process. And of course, the forums that we've been conducting. So this is our 6th public consultation forum today. We've had 3 now. This will be the 3rd one that we've done via video conference. And we've had a number of sessions across the state face-to-face before the ravages of COVID-19 came about and brought the travel and the mingling together. So we are now socially distancing, but fortunately it's at a time where the internet is allowing us to meet and do this in a coordinated manner. The closing date for submissions for the statutory review has been extended to May 1, taking into account some of the disruption that COVID has caused. And one thing that Kim might be doing as part of reviewing all the feedback that comes forward in both the sessions and in submissions and the survey, he may need to go back to submitters to clarify some points. So that might happen between now and a couple of months' time. And obviously the outcome of the review is a report that Kim will author and provide to the Deputy Premier. And the Deputy Premier has an obligation to table that report in both Houses of Parliament before the 1st of February next year. Now that might seem some time off, but what needs to be borne in mind is that Parliament in New South Wales will rise at the end of November and won't sit again before February 2021. So in effect, the report has to be finished well before that and provided to the Deputy Premier. So we're working on some reasonably tight timeframes. And obviously COVID's been problematic for everybody, but that's the reason why we're working towards the timeframes that we have, because the Deputy Premier has a statutory obligation to have that report tabled. I'd now like to introduce you to our independent reviewer, Kim Bills, before handing over to Kim to take you through the discussion paper. We're very fortunate here in New South Wales to be able to have engaged Kim as the independent reviewer, because he brings a wealth of experience and knowledge in a variety of settings and industries that are ideal for undertaking a review of the mine and petroleum site legislation in New South Wales. Kim was the project manager for the National Mine Safety Framework, which some of you may remember was essentially the lead-in to the legislation that we have today. And that process involved stakeholders from all states and territories in Australia, and it was the mechanism by which the model work health and safety mining regulations were developed. Kim was also the founding executive director of the Australian Transport Safety Bureau, the role he held for almost a decade. He's also been a board member of NOPSEMA, the regulator of the offshore petroleum sector here in Australia. He's been a lead investigator. He's also been employed at the Commonwealth level in government, and he's the current chair of the College of Fellows for the Australian Institute of Health and Safety. So he understands government, he understands regulation and legislative reform, he understands what it is to work and regulate high hazard industries, and he still has an active involvement in health and safety. So he comes with a very impressive track record, and he's the ideal person to be undertaking this independent review. So on that note, I'd now like to introduce you to Kim Bills, and Kim will start to take us through the discussion paper and the terms of reference. Over to you, Kim.
Thank you very much, Tony, and good morning, those of you online, and greetings to those of you who may be watching this subsequently, whatever time of day or night that may be. So what I'll try and do is to reference the discussion paper as we go through, so that if you've got it with you, you can find the relevant pages now, but otherwise you can check a bit later on. So firstly, the terms of reference for the review. You can find these starting on page 7 of the discussion paper. And the key thing about the review is this particular slide takes a very high level view, whether the work health and safety, mines and petroleum sites laws assist in securing the objects of the primary act. That's the one that Tony referred to cover, that covers work health and safety throughout New South Wales and all workplaces, for the protection from harm of workers and other persons on mine and petroleum sites from health and safety risks. Are there any areas of those laws that have unintended outcomes or consequences, and do the laws remain consistent with the principles of the National Mine Safety Framework that we'll talk about in a moment? So they're the high-level terms of reference. The next slide gets into a bit more detail, and basically it's picking up the objects of that act, of the Mines and Petroleum Sites Act, excuse me. And so what we'll do is go through all of those various bits as we go through the discussion paper, but that's where the terms of reference came from the objects of the Act itself. And then the third slide is basically a process slide. In section 77, it says you've got to have a review of this Act 5 years after it commenced, and which is why, as Tony said, this Act is being reviewed now, and it's being done in conjunction with the regulations, because a lot of the action deriving from the heads of power in the Act are in the regulations. So we might have the next slide, please, Tony. So my review, we're on page 9 of the discussion paper now, to lead discussions with you, the stakeholders, and others across the state, and listen to any concerns, to review inputs, excuse me again, from face-to-face and now these online forums, from formal submissions, and from the results of the online survey. And just to say a couple of things about those, when you go through the discussion paper, if you do it online, all the questions that you'll find there in the various sections have got sort of blue links that if you click on it will take you through to the Act or to the regulations. So that's to make it easier for you to find them quickly if that's the bit that you want to find out a bit more about. There's a template where you can answer all of the questions by following the template. It may be that most of the time you don't have an issue with whatever is raised in the question, and that's fine. You don't need to fill it in if that's the case. If you do have an issue and you say there's been an issue, there's a problem here or whatever it is, if you could put in a bit of text about what the problem is and maybe even how you think it could be solved, that would be extremely helpful for me. If you don't want to use the template online for a formal submission, you can do an online survey, which is an even simpler process, or you can do something entirely different and just send a 1 or 2 page or however many page, depending on whether you're an individual or an organisation, submission to me, highlighting the areas that you think need to be looked at or desirably could be looked at. So there's all those options in terms of inputs, and I'll be looking at all of them after the 1st of May when it all closes. I'm not a domain expert. I don't pretend to be an expert in mining, nor am I a lawyer, so I will be relying on Tony and John and their colleagues to assist me in some of the detail as I work through the submissions. But at the end of the day, the report's going to be my judgment, and that's the one that will go to the Minister. And of course, it's then up to the Minister to decide how he wants to proceed, and if he thinks changes need to be made to the legislation or regulations, there'll of course be a separate process of consultation with stakeholders at that time. Okay, so now getting into the meat of the discussion paper, there's 3 sections. The first one's about national context. That starts on the bottom of page 9 of the discussion paper, and it just lists the various questions, but the guts of it begins on page 11, where it refers to the intergovernmental agreement that was signed by all states and territories and the Commonwealth in the middle of 2008, and that's the one that committed everyone to harmonising their work health and safety legislation across the country. That's mostly happened. All bar 2 jurisdictions have introduced the Work Health and Safety Act, and of the 2 that haven't, Victoria's was in many ways the basis for the Work Health and Safety Act itself, so it's quite similar. And Western Australia is this year finally legislating that act, and it's also got some regulations that we'll talk about in a moment. So that's the part of the national context. Page 12 of the discussion paper, and the next slide please, Tony, refers to a process particularly for mine safety, which was the National Mine Safety Framework that, as Tony said, I was involved in between 2009 and 2011. And there are a few dot points, or 7 in fact, on page 12 that talk about the key areas that were agreed and that were sought: nationally consistent legislation, coordinated enforcement, and so forth. So you'll find them there. And question 1 is, do the New South Wales Work Health and Safety, Mines and Petroleum Sites laws remain consistent with those principles? Now, without trying to lead you too much, my view is that they do remain consistent. And in fact, New South Wales was the only one of the major mining states that put them into law. But of course, that doesn't mean, consistency doesn't mean they can't be improved. And so that's the guts of this exercise. We'll be looking at that. But if you have a view that for some reason there's an inconsistency, question 1 is the place to answer that. So the next slide, please. And it's really talking about the fact that there was a desire to have this nationally consistent mine safety legislation that I've spoken about. And question 2 is really following up on that. So it's similar to question 1 in one sense. Next one. So for the big mining states, for New South Wales, Queensland and Western Australia, there was an additional process. But for all states, there was a tripartite process involving regulators, business and employee groups, so unions in particular. And that led to some drafting instructions for a chapter on mine safety under the Model Act, and that was Chapter 10. So the jurisdictions that aren't big mining states have put that into practice, with the exception of Victoria. Question 3, though, is about has that overall framework facilitated regulatory cooperation? And my view is that regulators are cooperating. With cooperation, you can always do better, but that's a question of time, but also the fact that there are differences has put a bit of an impediment. That's question 3. Okay, next slide, which is really talking about the additional process for the 3 big mining states who wanted to address very high risk mining activities like underground coal, but in Western Australia, there's some very big metalliferous mines as well, as there are in New South Wales. So that was an additional process that was undertaken. The end of that was that New South Wales legislated what we're talking about now. Queensland in the end got right up to the barrier and decided not to do it. And Western Australia is this year legislating both the Work Health and Safety Act, but their structure is to have 3 sets of regulations under the primary act rather than an additional act along the side like New South Wales. And those regulations in WA are set around general work health and safety, a set around petroleum safety, and a set around mine safety. And question 4 asks, are there any developments in those other major mining states, so WA and Queensland, that could improve safety, regulation and outcomes in New South Wales? So there haven't been too many developments in Queensland since the process of forming this these drafting instructions concluded. But WA, there is this new material that's being dealt with this year. So that's question 4. Next slide. So now we're into the Act itself. So we've talked about the context. And so the question, the overview of the Act itself begins on page 14 of the discussion paper. And it talks about the objects of the Act being implemented in mine and petroleum sites, including, of course, securing and promoting the health and safety of persons that work on those sites. And this slide just mentions that the Secretary of the very large Department of Planning, Industry and Environment, in which Tony and John sit, is formally the regulator for mines and petroleum sites, but in practice, that office has delegated a lot of the day-to-day regulation to the resources regulator based in Maitland. So question 5 is a very broad question. Are the objects of the Work Health and Safety MPS Act still valid, appropriate and working as intended? And those objects, as I said, you could find when we talked about the terms of reference for the inquiry back a few slides, but also, of course, in the legislation itself. Okay, next slide, please. So the Mines and Petroleum Sites Act establishes a primary duty holder, and it's in mining and petroleum, there's either a petroleum or a mine site holder and generally an operator. If it's an operation of any scale, often the operator is a corporate entity, and the duties, the primary duties under the Act sit with the person conducting a business or undertaking, which is usually the operator, and the additional Mines and Petroleum Sites Act includes extra duties on this operator for mine and petroleum sites. So question 6 is, are there any areas arising from the laws that have had unintended outcomes? So if you want to say anything at all about the Act without getting into any of the sections, this question allows you to do that. It's a really open-ended question. Okay, next slide, please. So there are some provisions in the Act that aren't just establishing heads of power for the regulations, and this slide talks about some of them, which is reporting particularly serious things like workplace deaths, injuries, illnesses, and dangerous incidents that have to be notified to the regulator, and that has to be done very quickly after the operator becomes aware of it. So question 7 refers to those provisions for incident notification and whether they're valid, appropriate and working as intended. will come under the regulations to the less serious ones that are also still important. And in previous consultations, there have been some views that maybe some of the wording of those could be improved, or there should be more of them or less of them, but we'll come to that in due course. So the next slide, please. Just find out where I am on the in the discussion paper. I'm sorry I haven't been giving you all the page numbers. So there are heads of power in the Act for government officials to regulate and inspect. And question 8 is around the provisions for the functions of those government officials. Are they still valid, appropriate and working as intended? So heads of power, and so we're not really talking about the day-to-day operation of the inspectors, because people have different views on how that may have worked in practice. It's really the powers in the Act that this question refers to. Okay, next slide. And I should have said that the page number for those two previous slides on incident notification and the functions of government officials, page 17 of the discussion paper. Okay, worker representation at coal mines, because of the high hazard nature of particularly underground coal mining, there are two different types of safety and health representatives. The ones that are elected by workers for a particular mine site, the mine SHRs, and then there are also 4 that are across the state. There are industry safety and health representatives appointed by the Minister. And question 9 asks about are those provisions for representation in coal mines still valid, appropriate and working as intended? On to the next slide, please. Okay, enforcement measures. I think we're now on page 20 of the discussion paper. And this is giving powers for government officials to issue improvement and prohibition notices and stop work orders. And question 10 asks about those provisions for enforcement and whether they're still valid, appropriate and working as intended. So working as intended in a sense of, are they legally working sensibly, rather than has some individual used a prohibition notice in a way that the person who received it may not like. Although, of course, there is a process to appeal that if that should happen. On to the next slide, please. Boards of inquiry. So this is a power that's in the Mines and Petroleum Sites Act that hasn't been used yet. But what it does is, if there's a serious accident or maybe a series of events that the Minister thinks are very important to have experts look at, he can set up a board of inquiry, or he or she, if it's a female person in the future, a board of inquiry to look into that without having to go through the complex and very often lengthy and expensive process of a judicial inquiry or a royal commission. So question 11 asks, are the provisions for a board of inquiry still valid and appropriate? Of course, no one can answer, are they working as intended, because they haven't been used yet. But I believe it's an important provision to have there. Okay, in terms of statutory bodies set up under the Act, this is page 21 and 22 of the discussion paper. There are 2 of these, the Mine Safety Advisory Council and the Mining and Petroleum Competence Board. Question 12 asks about whether those provisions are valid, appropriate and working as intended. And then the next slide talks about the composition of representation on those bodies, both the MSAC and the MPCB. And question 13 asks about whether that representation is adequate. Okay, next slide, thank you. So here we move from the Act to the regulations. And so we're starting on page 22 of the discussion paper. And just giving a bit more detail about this question of an operator, if they've been appointed by the mine site holder or petroleum site holder, and the fact that the operator's got to notify changes of contact details and so forth. Question 14 asks about those provisions for nomination and appointment, whether they're still valid, appropriate, and working as intended. Okay, so we're on to page 23 now, and this slide talks about the primary duty to ensure the health and safety of workers so far as reasonably practicable by managing risk. I'm sure most of you, if not all of you, are very well aware that so far as reasonably practicable doesn't mean that if you haven't got much money at the moment, you can't do something that's important for health and safety. In fact, the cost of whatever that something is has to be grossly disproportionate as the legal test for it not to be required to be done. And that test dates from 1946 in a UK case involving their National Coal Board. The second dot point here talks about essentially the hierarchy of control, so elimination and then minimising so far as reasonably practicable risks to health and safety. And there are also control measures that we'll talk about in a moment. But question 15 is a broad one. Are the provisions for managing risk in addition to the WHS regulation still valid, appropriate and working as intended? Okay, next slide. So we're talking about here, this is safety management plans, principal hazard management plans and principal control plans, which, and the discussion paper on page 23 at the bottom, flowing on to page 25 is where you'll find all this text. Obviously, a safety management system is absolutely critical, but there is also the need for principal hazard management plans if a particular hazard, principal hazard is in existence. You, of course, don't need a plan if the hazard isn't there. And there are also principal control plans. So question 16 is, are those provisions for the safety management system, including the hazard management and control plan, still valid, appropriate and working as intended? Okay, the next slide, please. Okay, so certain risks have to be managed using specific control measures, and there's some examples there on the slide. And of course, more detail in the discussion paper on page 24 and 5. And question 17 is, are those provisions for specific control measures still valid, appropriate and working as intended? Okay, on to the next slide, please. Emergency management. So just check up where we are. So that's on page 29 of the discussion paper. Just before I go there, you'll find on page 25 and 26 a reference to contractor management. That is a very important topic because quite often when an accident happens, those of us who investigate them find that there's often an issue where there's a misunderstanding or a miscommunication between a PCBU, the mine on the mine site, for example, in control of the mine site, the operator, and a contractor that may come in with its own safety management system and different procedures, and there's confusion. So I think it's important that A, everyone is aware of that risk, but B, if there's anything that could be said to improve the interface with contractors, I'd be happy to hear that. Okay, onto emergency management, as I said, page 29, and that varies, of course, by the scale of the operation and where it's located. Very important. So question 18 is about those provisions. Okay, the next slide, please. Okay, so page 30 of the discussion paper covers this topic, which is the important one of operators making sure that workers and those on their mine site have appropriate information, training and instruction so they know what the hazards and risks are. And question 19 is in relation to those provisions. Okay, next slide, please. Okay, so the regulator has powers to direct there be health monitoring, and this can particularly be in relation to, say, dust diseases, but it could be other matters as well. And question 20 refers to those provisions for the regulator to require health monitoring and whether they're still valid, appropriate and working as intended. Next slide, please. Okay, operators have a duty to consult with workers in relation to their safety management systems, risk assessment, hazard management and control plans, including emergency response, the role for workers and fitness for work. And operators have a duty to implement a safety role for workers, so it goes back the other way. Question 21, are those provisions for consultation and a worker safety role still valid, appropriate and working as intended? Next slide, please. So survey plans, so excuse me, page 32 of the discussion paper is where you can find this, and it's an important topic because in the past, as you know, there have been underground mines where there have been inrush of water problems or instability and collapse issues because there haven't been proper plans in relation to adjacent mining, etc. in the past, for example. So question 22 is about the provisions for survey plans and mine plans, which of course do vary depending on the type of mine and the scale and so forth. Next slide, please. So we talked about some of the really serious incidents that need to be notified that are under the MPS Act, but these are the ones under the regulation that are in addition. And as I mentioned, there have been some discussions around these in particular in previous forums. And question 23 asks, are the provisions for notifications and information to be provided to the regulator and kept by the operator still valid, appropriate and working as intended? So the next slide, which I think is we're on to the second to last question, and this relates to statutory functions and having competent people holding statutory and other key, particularly key statutory functions. And question 24 is, are those provisions for statutory functions still valid, appropriate and working as intended? And the final slide going through the discussion paper talks about authorizations and licensing. So statutory functions is on page 35, authorizations and licensing are on the last two pages of the discussion paper, 36 and 37. And there are some particularly important ones for underground mining, like diesel engine systems and powered winding systems and booster fans, where there has to be a registration every 5 years, but others, it depends on the type of mine and what hazards are there. Question 25 is using the same format as all the others pretty much. Are the provisions for licensed activities and registration of plant still valid, appropriate and working as intended? So that's a pretty quick run through the discussion paper. As I say, you can, as you go through it online, you can click on any of those bracketed things at the end of the questions and go get straight into the detail if that's what you want to comment on. So I might now hand back to Tony for a moment and we'll see what questions we might have, and he can say what I may have missed out as I went through.
Thanks, Kim. Look, I don't think you missed anything. I think you covered all the key issues there. So I hope everybody's found that overview useful and interesting in starting to crystallise any thoughts you had in relation to submissions or participation in the surveys that you may decide to undertake. What we'd like to do now essentially is throw the floor open, so to speak. So there's two ways you can pose a question or a comment. And one of the things that Kim's particularly keen to hear from is thoughts from people in relation to what the key issues or the key themes that need to be considered by the government in the review of the legislation, and to ensure that Kim's able to consider that and reflect that in the report. So any particular area of interest that you think needs to be flagged today that you'd like to raise with Kim. So you can either do that in the Q&A section. So we've already had a test done this morning. The Q&A function is working. So it's simply a case of going in, clicking on the Q&A and typing in either your question or your comment. So we can consider that and start the discussion around that. Alternatively, the option there is to actually verbalise your comment and your question. And the most effective way to do that is simply to raise your hand. So click on the button to raise your hand, and then we'll then bring you in so that you can ask the question or make the comment. So what we're looking to do now is have a bit of a discussion about the key themes. So just while you're doing that, so we're waiting for hands to be risen or questions to be answered. So Kim, in the sessions that we've undertaken thus far, both the online sessions and around the state, there's been a number of different areas of the legislation that have been raised. And just before we sort of go to that, I can see that we've got our first question or comment coming up, and it's Jeff Hender from out at Broken Hill. Jeff, so can you hear me okay? You there, Jeff? Jeff, you've got, it looks like you've got your system on mute.
How's that? Tony, can you hear me?
Yeah, that's better, Jeff. We can hear you now. So would you like to...
Just for your information, I've got Chris Tindunya and Andrew Flynn here with me as well.
Great. Morning all.
Morning. My question or comment, I guess, is the question around question 24 in the statutory functions. Has there been consideration, or has there been other questions in regards to the SSE type role in terms of the statutory functions? In the introduction.
So, yeah, Kim, you might like to go a bit further on this, but yes, there has been, Jeff, there's been at a number of the different sessions that we've had, there's been a suggestion for the creation of some additional statutory functions, including site senior executive. So if I recall, Kim, that was one of the suggestions that came up at the Dubbo session that we had. And that effectively would be, the suggestion was it'd be modelled on the Queensland position of site senior executive. That's correct, Kim?
Absolutely correct. I'm not sure what I can add to the fact that it has been raised already, but it's so I'm happy to hear that. But Tony, given that you've raised the other suggestions for additional statutory functions, maybe we should just refer to what they were. So yes. Particularly, well, I'll let you do that.
Yep. So there's been suggestions for the introduction of a mechanical engineer or mechanical engineering function in the non-coal sector, particularly in the underground sector. There was also reference to geotechnical engineering statutory function that's been identified. Was there another one, Kim, that we've had?
Was there mechanical or? Mechanical,
yeah. So mechanical engineering, so largely replicating the mechanical engineer or engineering manager functions that exist in the coal surface and coal underground sectors, and for that to be applicable to the non-coal sector, in particular the underground metalliferous sector. So yeah, so Jeff, going back to your point, there has been a suggestion of at least 3 different statutory functions being considered as being incorporated into the scheme as it stands. Yes.
Okay, well, I guess that responds to my question, and I guess my comment in support of that is I mean, that could be in smaller operations, dual role in terms of the mining manager and the SSE being rolled into one. But particularly in complex and larger operations, I see the SSE being something that needs to be considered to have the responsibility for the whole of the operation when these guys are actually looking after the underground functions rather than the whole of operation. So just to support that.
Yep. One point that we did make at the Dubbo session, and we'll make again here today, is that when the regulation was developed back prior to 2015, it was done so as part of what was known as the Tri-State Legislative Working Group. So that was a working group comprising New South Wales, Queensland and Western Australia. And that group looked at all of the statutory functions that existed across the 3 states with a view to coming up with a standardised set of statutory functions that would apply. So in the case of New South Wales, we decided to adopt the underground mine supervisor statutory function that exists in the Western Australian legislative framework. However, consideration was given to the site senior executive role that exists in Queensland, but the decision was made not to introduce that in New South Wales, largely because of the different duties framework that existed between the two, and noting that here in New South Wales, under the Work Health and Safety Act, the concept of PCBU is the primary duty holder, and therefore the decision was made not to have a primary duty holder be essentially the person conducting the business or undertaking, which can either be an individual, a natural person or a corporation, and then have another additional individual who would have essentially a role not that dissimilar to the site senior executive. So that's just a bit of background that was provided there. So thanks for that comment, Jeff. So just Kim, while we wait for the other,
just before you move on, could I just ask one more question? Jeff may have a view on this, or others may have a view on this. Queensland is in the process of amending some of its legislation, including with regard to statutory duty holders and SSEs. And in particular, for the SSE, it's trying to, it's in the process of making them all required to be employees. And the argument they're making for that is that an employee is less likely to be intimidated from doing the right thing on safety, effectively, to paraphrase it. My personal view is that there's no reason why an employee is more likely to be less intimidated than a contractor, because the employee may have his family near the mine site and may have a mortgage and may have more to lose if he thinks that he can have action taken against him if he does the right thing. And in terms of contractors, particularly for smaller operations, it may be that a part-time person is more relevant. So there are arguments around this, but anyway, I guess the question is the Queensland SSE role is in the process of changing somewhat, and so if there were views on that, I'd be interested to hear them.
Firstly, I'll comment on the contractor role for some of those statutory functions, and I'll draw the attention to the electrical engineer function. I would think that a lot of operations would struggle to find an electrical engineer for each separate operation for a start, because we use the contractor for our electrical engineer function and our mechanical engineer function. The availability of those qualifications is quite short for a start, and I would imagine that the person that we have is very likely holding that ticket for other operations as well. So I'll just put that firstly on the table, and so in support of retaining the contractor and rather than employee. I personally don't see the variance in responsibility in terms of safety. Those guys take their roles extremely seriously, and I think that should be considered. In terms of the SSE and the PCBU, the variance there is that the PCBU don't see that as a statutory function. And in fact, when the regulator comes and meets with us, they're always referring to our mining engineer managers as having overall control in terms of the statutory function, and don't reflect or refer to the PCBU. If that was the case, then that would possibly take the place of the introduction of an SSE if there was more strength put towards referring to the PCBU as the overall overarching control of the site. Food for thought.
Yep. Thank you.
Thanks, Jeff. So, Kim, as I was saying, so just while we wait for some more questions or comments, we've had a variety of issues that have been raised around the jurisdiction, around the sessions that we've undertaken across the state. One thing that did come up, particularly at a number of the face-to-face discussions, because we did those in the regional areas where there was a lot of participation by the metalliferous and the smaller mine sector, was the concept of the proportionality of the application of the specific requirements to mines, taking into account the nature and complexity of those operations, bearing in mind that the mining sector in New South Wales ranges from very large underground and open cut coal and metalliferous mines to some very, very small quarries. So you're sort of keen to know what people's views are about the proportionality of the application of the laws?
Absolutely. So certainly, and the opal miners, Lightning Ridge, for example, were keen to retain their existing arrangements for proportionality, given they're often incredibly tiny operations. But as you say, in some of the regional areas, whether it be a council or whatever, with a small gravel pit, there was some concern there that maybe they were being required to produce control plans at great expense that were really, for example, in the electrical area, that were not really required for that operation and the risks involved. So if there are comments around that sort of thing that are based on evidence, we're only 5 people and we're required to do X, Y, and Z, and it's not really proportionate to risk, then it would be good to hear that for sure.
So if you've got a question or a comment, you can either use the Q&A button or raise your hand, and we can bring you into the discussion. The specific risk controls, Kim, which are a key element of the regulation, has also attracted quite a bit of discussion at the sessions that we've had thus far, recognising too that a large number of the specific risk controls obviously apply to coal mining and underground mining, because it's reflecting those additional and specific hazards that are related to that type of mining. So that's another area you're particularly interested in to hear people's thoughts about the suitability and the effectiveness of those risk controls, or whether or not there's some additional risk controls that people might believe are necessary.
Yes, because we've heard both sides of that argument to some extent. We've heard people in the metalliferous world saying that there's too much coal stuff that's an overburden, if you'll excuse the pun, on our operations that shouldn't be there. But we've also had people in metalliferous saying there are some good things in coal that we don't have yet. So obviously I'd be happy to hear either, but as I said at the outset, if there are suggestions for change, if you could just be clear on what they are, but also why. Some evidence would be fantastic.
And most people would be aware that the safety management system and the principal hazard management plans and principal control plans are a key element of the regulation, and it's what sort of helps distinguish this framework from just the general regulation. I think, Kim, there's been a reasonable level of, satisfaction from participants that we've discussed this with at the sessions thus far about the appropriateness and the level of detail that's required in the SMS and the control plans and hazard management plans, particularly taking into account the fact that the regulation appears on the face of it to be flexible enough to allow mine operators to develop those plans, taking into account the type of operation that they have. But again, that's one area where we're that you're keen to know whether or not there's any impacts of the way the regulation is drafted in relation to those requirements that are having an effect.
Yep. So, if it's possible to simplify or to reduce unnecessary requirements without compromising safety, I think that's a win-win. So, very happy to hear any suggestions along those lines. But quite often, as you may have been alluding to, Tony, particular companies or operations put in place systems with levels of detail that they've actually imposed upon themselves, or maybe someone in the past told them do it like this, or whatever it may be. And if you look at the legislation and the regulation, it's not actually required. So I think it's a good opportunity to do have a bit of a look at what you're doing and whether you really need to do it. And you know, that may be the case. We've had comments along the way of take fives and, you know, various swims and all the rest of it that can serve a useful purpose if they're done properly. But if it's just going through the motions exercise and it's sort of making sure there's a stack of them there because, you know, maybe they're going to be useful in the future, that's not really helping anyone. So there really is an opportunity to look again. But if the reason why there's this unnecessary bureaucracy, if there is the Act or the regulations, then obviously I'd like to hear that.
Yes, and look, as we've noted at all of the sessions thus far, Kim, since the introduction of the regulation and the Act in 2015, there's been a number of amendments that have been made to certainly to clarify things, but also to look to remove regulatory burden that's considered unnecessary. You know, some of the more recent examples we've had is to reduce timeframes around giving notice to the regulator. And we're currently, the regulator is currently looking at removing some obligations in relation to annual reporting, particularly for a large number of smaller mine operators. So to take that burden away when it's considered unnecessary. Just to point out to everybody too that the review that Kim is undertaking is looking at the legislative framework. It's actually not looking at how the legislation is being implemented or being enforced. So he's not looking at the role of the regulator, although there are some elements of the regulation that relate obviously to appointment of inspectors and enforcement powers and so forth. But he's not looking at the performance of the regulator. It's looking at the Act and the regulation. However, if there is a matter in that you think is an issue in relation to how the laws are being enforced, it's important that you include in your submission the nexus or the reason why it's the legislation that's causing the problem, not how it might be applied at a particular point by a member of the regulator staff. And I guess, Kim, just to reinforce, what you are actually looking for is not only that there's a problem, but why it's a problem. So that reasoning as to why there's a deficiency in either the Act or a regulation, or a reason why something additional should be created. So the evidence to support the proposition that's put forward.
Absolutely correct. And I'm not sure that we said at the outset that submissions will be online. My report's going to be eventually public after the Minister tables it in Parliament, but everyone will be able to see to what extent the submissions have been addressed in the report, so it'll all be very transparent. But when you're making a submission, if there's a particular aspect of privacy, you know, like your address or whatever it is, then of course that doesn't have to be put online, but we aren't taking anonymous submissions because we need to know who's making them, even though privacy can be dealt with when it's actually put online.
That's right. So the regulator's position is that submissions that are received, the identity of the submitter will be published. unless of course there's a good reason as to why that's problematic, and that could be a safety or a security issue, or in not so much in the case of this review, Kim, but in other consultations that we might undertake if there are matters of commercial and confidence that are particularly relevant. So the regulator will consider that. But yes, all submissions will be published, and that's to ensure that there's transparency around the consideration of government in deciding whether or not to retain or to make amendments to legislation that are in place. And look, just reinforcing to everybody that the review is looking at the whole legislative framework. So whether you're in the coal sector, the large metalliferous sector, the large quarry sector, the small quarry sector, be it local councils or a small family-owned operation, exploration. So obviously we're very keen to hear also from the exploration sector, because they are regulated under this laws. So every sector, when Kim is looking for input and views about the legislative framework. Kim, I guess one thing is we're not expecting, whether it be a formal submission of the discussion paper or the survey, we're not expecting people to provide a comment on each and every aspect of what's in the discussion paper or the legislative framework, just to focus on those things that you think are of most concern, the key issues from your perspective as a person in the sector, and don't feel as though you have to provide commentary on everything. I think, Kim, the general assumption will be if you don't provide any comment on particular sections of the legislation, the assumption is that you don't have any great problem with it. Is that a fair point?
I believe so. And look, I've said in some forums that people hate change for change's sake. So if legislation and regulations basically working pretty well, it would be silly to change it unnecessarily. But so I want to zoom in terms of this report to the Minister on things that can be changed that will make a difference and improve things. So the things that are working well, if you want to say you're broadly happy, then that's fine. But otherwise, as Tony said, we'll assume that no comment means that you're broadly happy.
So I guess, Kim, on that note, at this point we don't have any additional comments or questions being posed. So the takeaway message from today is that things must be reasonably okay, although it's probably more a reflection of people gathering their thoughts about what would be included in session. So look, if you do have any questions for Kim about the review process or myself, or any comments that you do want to make, if you could just either raise your hand or type it into the Q&A. But otherwise, we might look towards wrapping up the session. Look, just in terms of the process going forward now. So Kim will be taking into consideration all of the information that's been provided through the public consultation sessions, and then obviously the formal submissions that are received as part of the process and the online surveys, and developing his report based on that. Remembering too that, as I mentioned at the start of the session, that if there are any matters where Kim needs to clarify things, he will come back to you, just to be sure that he fully understands the issue or the concern that is being raised. And obviously the outcome of the review is the report that Kim will be preparing for the Deputy Premier, and remembering that report will be tabled in both Houses of Parliament, and it'll be done so before the end of the year to ensure that the Deputy Premier can meet the legislative timeframes for having that published. As Kim indicated, we'll also be publishing each of the submissions online. So you'll be able to see what the various comments and views put forward by the different people who have provided submissions. The closing date has been extended to May 1, and that's obviously to assist in people dealing with the impacts that COVID-19 has had on everybody. If you haven't already had a look, all the information about the review is available on our Have Your Say section of our webpage. So as you can see there, so if you just go to resourcesregulator.nsw.gov.au. Either type in "Have Your Say" in the search button or click on "About Us, Have Your Say." You'll find the link to all the information about the review, and that includes the discussion paper and the templates for the formal submission and the link to the survey. So one more thing just before we do wrap up, and just seeing if there are any additional comments or questions. Those people who are practicing certificate holders who have maintenance of competence obligations, today's session is an opportunity for you to claim some learning hours as part of your maintenance of competence, and you can do so by categorising it as informal learning under legislation. So if you are a practicing certificate holder, you can claim that, so you can mark that down on your log sheet if you are keeping one yourself. Alternatively, if you are using the Cold Services app, you can put your phone or iPad or tablet, whatever you may use, the camera up to that QR code that's on the screen now, and that will enable you to register your attendance at today, and that will be updated into your app subscription with the Cold Services app to record your maintenance of competence. So 3 hours of learning is eligible for today under informal learning under the topic of legislation. So we've had a number of people who have attended the sessions have taken advantage of that. So just look, one last final call for any comments or questions. So either type them into the Q&A section in the box, or raise your hand and we can bring you on to talk. Kim, are there any final comments that you wanted to make before we wrap up the session today?
Not really, Tony, just to thank people who attended online and those who've seen this subsequently, and just to encourage people in whatever form to make a submission or to at least fill in the survey. I'd be very grateful, and look forward to your comments and your thoughts for how the system could be improved from what it is today. Thank you very much.
Great, thanks, Kim. So on that note, everybody, we'll wrap up the session. Again, we thank you for your attendance and participation today. It's been a very productive public consultation process that we've undertaken thus far. Obviously, the COVID-19 has proved a little bit problematic for us, but thankfully, with the technology that's available today, we've been able to continue and have the face-to-face session. So we hope that you found it useful in terms of better understanding what the review is focusing on. And as I mentioned, there's a couple of options for you: a formal submission based on the discussion paper, or participation in the online survey. Happy to accept them either way. And just reminding you that you don't need to provide a comment on each and every aspect of the legislation that's been identified in the discussion paper. Feel free to just focus on the issues that are of most concern or most importance to you. And as Kim has indicated, if you make no comment about other parts, the general assumption will be that you don't have any concern about the validity and the objectives being achieved by those. So on that note, we'll wrap up the session. Thank you. Thanks again for your participation. Good luck with continuing to manage social distancing with COVID-19 and how you're doing that both in a personal and a professional sense. And we look forward to receiving any submissions that you have in early May. And on that note, we'll call it a day. Thanks, everybody.
Thank you.
And have a great week.